We all are products of our communities, of our society, of our families, of the education, and we bring this to the bench.
Are we still subjects or are we really citizens?
The process was the punishment earlier. The process is the punishment now.
Public-private partnerships, they'll more and more of such will come forward to advance and progress the work which has been the legal framework laid down by the new criminal law.
The most application of mind that has happened with respect to these laws is by our colonial masters.
About 2 years ago, the country witnessed what was termed to be a most significant overhaul of the criminal justice system in independent India. The enactment of the 3 new criminal laws, the Bharatiya Sanhita, the Bharatiya Nagarik Suraksha Sanhita, and the Bharatiya Sakshya Adhiniyam. These replaced the Indian Penal Code, Code of Criminal Procedure, and the Indian Evidence Act. These laws, particularly the new Criminal Procedure Code, the BNSS, were framed as transformative, as a shift towards a modernized, decolonized, and citizen-centric justice system, one that prioritizes justice over punishment. The promises were faster procedures, shorter trials, higher conviction rates, and a criminal justice system that serves its citizen in a better way. Do these procedural changes actually impact how procedure is being implemented on the ground in India? And what does reform of such scale look like really in practice? And this report is an attempt to answer that question. The perspectives that we will be sharing here today were collected from people actually implementing these laws on a daily basis. We spoke to judicial magistrates who handle a variety of criminal cases, and we spoke to police officers who were investigating petty crimes to heinous crimes such as murder and robbery. It is their perspective that helps us understand whether the intent of the law is really translating into practice.
But there was one very important acknowledgement in the bringing about of these 3 laws, and that was that India's criminal justice system continues to be colonial, and it continues to lack citizen centricity. And something that we will discuss today is whether BNSS has changed that, whether BNSS has changed the lived experience of criminal justice in India.
So I was allocated a single bench criminal roster, and lo and behold, I get a case by a convict for section 375, 376 of the IPC, then those provisions. And the legal aid lawyer who was defending the convict was very vociferous. Hear this appeal, hear this appeal. So I said, you really expect an acquittal when the conviction rests on the testimony of an 8-year-old child, sole witness? He said, yes, there is no evidence. You, I presume, will all relate to the sections, so I won't elaborate. But during the police investigation under section 161, the policeman had recorded the child as having done buri harkatein. The 164 statement before a magistrate recorded galat kaam. And the sessions judge, an experienced judge, had recorded something equally innocuous as, shatani or something. I'm forgetting the exact words. It's been a long time. And obviously, these statements did not bring out the requirements of penetrative sexual assault, as was the mandate of the law then. So I went through the evidence to see if there was any other evidence to show whether the child had given or expressed anything about what had transpired. And the only question put by the session judge was, what do you mean by buri harkatein or galat kaam or whatever? And she had recorded the child as having said that it is what a husband and wife do at night. Now, is there a presumption? And is there only one thing that a husband and wife do at night? And there was nothing to show whether the judge had gone behind the scenes to ask whether the child could have any knowledge of any sexual interlude between a husband and a wife at night. So as I plodded through the evidence, I was a judge of only 3 years vintage and very careful about what I'm doing. When I saw the evidence, it showed that the father had said that he was a driver by profession, and his wife had abandoned the child and him when the child was 3 or 4 months. So obviously this, what a husband and wife do at night, was a tutor's statement. Buri harkate is not the language of a child. More so, it was a Tamil child giving 161, 164 and a testimony in Delhi. So we didn't know what language the child spoke. And the child didn't appear to have gone to school. There was no evidence of her being educated. So we don't even know what level of Tamil she could speak. What did this case highlight? It highlighted 3 very important barriers, and which I was very excited when I heard that criminal law was being amended would come across. First is linguistics as a barrier to accessing justice, especially for a victim of sexual violence. Second thing, even more significant, was the reluctance of even legally trained personnel to engage with matters involving sex. A policeman, a magistrate recording the 164, the sessions judge. And where does this come from? This comes from the baggage that we bring to whatever roles we have from our upbringing, from our education. Benjamin Cardozo said we all bring the well-known Chief Justice of the Supreme Court of USA. He always said we all are products of our communities, of our society, of our families, of the education, and we bring this to the bench. And nothing highlighted this more starkly than this judgment. And the third is the lack of assistance, interpreters, translators. You don't need interpreters only for a victim or a witness who's Tamil, but you need interpretation of evidence of mentally challenged personnel. I always put it to a room full when I'm training as to would you accept identification by a person, by a witness who's mentally challenged. And I've not come across a single person say they will accept the identification of an accused person by a mentally challenged person, which is terribly wrong. They find difficulty in accepting the evidence or understanding the evidence of hearing and speech impaired. None of us in this room, I don't know if there's any person who's hearing or speech impaired would be understanding the sign language that the interpreter here is using, So this assistance, I was hoping, would form part of the normal system, And you don't seem to be finding these kind of interventions.
So the legislative intent is great, it's laudable, and the BNS has responded to many long-standing problems and challenges in India's criminal justice system, which were felt by the police, by the judiciary, by the citizens, and different stakeholders in the criminal justice system. And also the police-public interface. So the attempt being at structural, practical reform, and of course it represents a big push towards transparency and accountability in the system on the one hand, towards increased use of technology, leveraging new technologies, digitization, forensics, with the view to bring about evidence-based policing on the other. However, we may have to wait for quite some time for the transformation which these laws had promised, and what the objective was towards a modern and citizen-centric justice system. Unless the basic issues, they are very, very basic issues, I just mentioned a few, which are plaguing the system, they are redressed. Whatever a sense of frustration which we feel today, which was articulated in the report also when Vidhi investigators and researchers went to the field, spoke to judges, spoke to cops, etc. So, the basic issues being all components of the criminal justice system, including the police, prosecution, courts, are, overburdened, clogged, even choked with the sheer number of cases it needs to handle. If I were to share figures of Punjab, on an average, around 75,000 FIRs are registered annually in Punjab. I was the DGP there, I was Punjab cadre, so I feel most comfortable using Punjab as a little example. Charge sheets filed annually are around like 60,000, arrests made every year are about 90,000. But if you look at, what are the total number of investigating officers who are available to the Punjab Police, it is 80,000 Punjab Police. That's the strength of the Punjab Police. There are only about 2,500 odd investigating officers, and that includes 800 head constables who can only, investigate a very small number of petty offenses and Excise Act or small, this thing. So, so that is the, those are the numbers. So BNS needs, massive investments in digital systems, forensic labs, large number of police personnel trained in investigations, IT, forensics, training of judges also in conducting electronic trials, appreciation of digital evidence. So there's a big learning curve involved here which needs to be surmounted. But of course, as is expected, in the short run, the implementation so far is uneven. There's a urban, huge, urban-rural divide also. I would like to say that many I's need to be dotted, many T's need to be crossed before we can, report or make decent progress. But I think we need to remain optimistic. These are good laws. They were required, and this is a lot of innovation, judicial innovation.
Right. I think some of the more serious offenses which have been introduced require some discussion. I flagged some of them, and since this is largely a legal audience, I think you will understand. 187.2, I think it was mentioned in the opening, in the Vidhi report as well, which is parallel to the earlier 167 of the CRPC, where the period of police custody, although that remains 15 days in total, but the police has the right to take staggered custody from 0 to 40 days and 0 to 60 days. I think that's a very, that increases carceral consequences, and that's something that we need to look into, because while interchangeable custody was permitted earlier within the first 15 days, you've now extended to a period of 40 days and in some cases 60 days. It's a very, very serious consequence and directly impacts personal liberty. That is one change that requires to be flagged. See, some of these sections I'm quoting not necessarily in the order of seriousness, but I noticed section 172, which is again a new section which was introduced, persons bound to conform to lawful directions of the police. Again, directly increasing carceral consequences, increasing the powers of the police to detain persons. While the objective of these criminal laws, we were told, was to shake our colonial lineage, I think we do that when we change the journey of a subject from a subject to a citizen. But when you have provisions like 172, where the police can say you have not followed my lawful directions, or that I can, for failure to follow lawful directions, I can keep you in custody for 24 hours. I'm not sure whether that journey is complete or whether it has even been attempted. Are we still subjects, or are we really citizens? The concept of zero FIRs was mentioned by you. I really don't want to emphasize more on that. Your report shows that it has negligible impact on the ground. But what I would like to say is that if you read the provision, the incorporation of zero FIRs in 173.1 reflects, to my mind, certainly some non-application of mind. The scope for misuse is clear when one reads subsection clause 1 with clause 3 of 173. Clause 3 empowers the officer in charge of a police station to conduct a preliminary inquiry prior to registration of the FIR, or to proceed with investigation in cases involving cognizable offenses punishable with 3 or more and less than 7 years. Now, the vesting of powers of investigation in an officer who does not have territorial jurisdiction is unprecedented. In my mind, it is dangerous, since it opens up a range of coercive measures which the officer is empowered to take against accused persons. And so while zero FIR is a beneficial provision for victims, I think the amendment in 173.1, read with 173.3, is a potential tool in the hands of the police to harass and intimidate individuals. The one provision that I found quite unpalatable was with respect to ex parte trial for proclaimed offenders. The new BNSS permits trials to be conducted in the absence of an accused. Now, this is a dangerous provision, as in a country as vast as India, it is foreseeable that a person is unaware of proceedings against him. And in such a case, if a trial is allowed to be concluded in his absence, it can cause grave prejudice to his or her rights. In the past, when a proclaimed offender was arrested, as you know, there was a provision to bifurcate his trial from that of those who were before court. And whenever a proclaimed offender was arrested, he he was given an opportunity to contest the case. Now that has gone completely. And I think this provision is fairly draconian if you look at the impact it has on accused persons. Now I know everybody is very excited about electronic evidence as though it will completely change the landscape. While it does change the landscape, and permit me here to introduce a section which is not for discussion today, but I need to say this. There was earlier certification under section 65B, the minute you produced electronic evidence, the person who had control of that electronic device would certify, as per the provisions of section 65B, that this evidence had integrity. Today, that certification is still there, but there's an additional requirement of an expert. Where do I get this expert? And not every case is a state case. There can be private disputes. The Evidence Act applies equally to civil cases. Imagine a woman who's filing a case under the Domestic Violence Act and has to prove a WhatsApp message, an abusive WhatsApp message she's received from her husband. Where does she go for getting this expert from? Now, Section 45, which defines experts, doesn't give us, which is now 39(2), doesn't give us any indication. But 79A of the IT Act provides that the central government may, for purposes of providing expert opinion on electronic form, it can certify who those experts are. So I need to find an expert for every piece of electronic evidence that I'm producing before the court. This is completely impracticable, and it should really be removed. Apart from that, I want to make two quick observations. One on Section 94 of the BNSS, which was the earlier 91 CRPC, which empowers a court or an officer in charge of the police station to direct production of not just documents, but now also electronic communications. This has opened a brand new world because every time, even if you protest outside, they'll ask you for your cell phone. And every personal information is with the state. I think it's time that the legislature hasn't done it. Courts must have guidelines as to which are the cases where they can take your electronic devices. Can it be routinely taken? What kind of evidence can they extract from it? Because it works both ways. A rape victim who is forced to give her phone then finds in court that her entire life history is known to the accused, which is then used by the accused to viciously cross-examine her and slut-shame her. So this overemphasis on taking mobile phones and digital devices without drawing the exact portion that can be used, and its supply to accused persons, can work to the detriment of both an accused person as well as a victim. When liberty is at stake, it doesn't matter if courts go the extra mile and insist on every aspect of procedural law being upheld. Because at the end of the day, you're looking at the life and liberty of individual citizens, not subjects.
The process was the punishment earlier. The process is the punishment now. Process which was supposed to lead us to that light at the end of the tunnel, a discharge, an acquittal, or justice. It's still a big, big problem because these amendments do not address the elephant in the room. Most of these amendments are symbolic. And there's a huge problem in symbolic legislation or legislative quick fixes. You know, it's very easy if you have a great majority to throw a law at a problem. But the real work of reform is about ensuring that that baby magistrate does not have 5,000 cases. You know, I'm just taking the liberty of doing that, and I'm referring to myself maybe. When I started off, and I had a great honor of having my Chief Justice then, when I started off as a magistrate sitting on the dais, Justice Mittal. So if I'm a little nervous, please pardon me on that. So when I started court, I would have 150 matters on the board every day, and about 5,000, 6,000 cases pending. Now you can tell that magistrate that you have 30 days to pass a judgment. You have 60 days to frame charges from the date of supply of documents till the framing of charges. You can have that timeline. You can have that symbolic timeline, but nothing is going to change on the ground. In fact, it brings law into disrepute because now you have a timeline that sits on the statute, but is every day violated in practice. And you're talking about rule of law, where you're talking about that a rule has sanctity. Because once that rule is violated, then it breeds a culture of defiance, right? So it has failed there. Now I was hearing this, and I don't know if this deserves a response, but one of the reasons, and this was one of the speeches made when the laws were being introduced, that offenses against women used to be around section 350, 360s, we brought them to section 77. So that's a reprioritization. It's no such thing. The sequence, the number, all of that hardly makes a difference. I do not know a single, and please correct me if I'm wrong, there's not even a single change in any of these three statutes, BSA, BNSS, BNS, that could not have been done by way of an amendment and not a repeal. You take a statute lock, stock and barrel, and then you rename it. Of course, that has its own set of problems. I'm not getting there today. But the cost, administrative cost of now people in the trenches, magistrates, investigating officers, legal aid lawyers grappling with the new law. And some of this is actually very, very badly drafted. I mean, it makes, gives one a reason to believe whether somebody ever visited a trial court. Now, 4 buckets. The good but poorly done, like botched up in practice, idea was good. Third is bad, out and out, an absolute horror show of a section. The fourth are missed opportunities. And I'll cover some of what's there in your report very quickly before we open the discussion. Videography of a search and seizure is good. A lot of the problems with the system stemmed from false implications. You know, we used to have these cases under the Arms Act, 25 Arms Act. You don't like somebody, somebody's inconvenient, just plant a knife or show a knife. Recovered. You don't need independent witnesses. The law said you needed independent witnesses, but you would say, we couldn't get or convince people to become witnesses to this search. This person had a knife, a button-dar knife, or illicit liquor, or some sort of a drug, and that's an offense by itself. So weaponization of the criminal law, false cases, was a big problem. Videography of a search may help there. But then again, this is good, but probably poorly done. Why? Because the law says it has to be done through a cell phone, preferably through a cell phone. Huge set of problems. Why could you not have a dedicated camcorder with a memory card in it, which would be dedicated to each of those cases, but you want to have a phone? And then you upload it into an e-Sakshya app. And this was all thought of much later, actually, where you now upload it on the web, where you do a videography of a search and seizure. And then later they realized we'll have to give accused a copy. But the design of the website and the server did not provide for how do you give accused a copy, because in 207 CRPC, one charge sheet is filed, you have to give every piece of evidence. But they hadn't figured that out for some reason. And later they realized that now do we give them user ID and password, which is the administrator access? Something as small as that. And there were charge sheets filed with so-called videographies of search and seizure, but nobody knew how to give accused a copy, because also what the court got was a link. They had to click a link and download or maybe watch it online, the search and the seizure videography. Enormous set of problems. We'll be cross-examining for days on what the original device was, what the metadata was, when did you do it, what device, and so on and so forth. So good idea, but practice leaves a lot to be desired. Zero FIR, again, big problems. The least you could have done was that if there is a zero FIR to be done, there is a time period in which the police officer should send it to the concerned police station. Now they have the wide uncanalized discretion to keep it for months, or maybe not keep it even for a day, depending on who are involved. Because the criminal justice system has this fascinating ability to be extraordinarily fast and very, very slow, depending on who are there. There are charge sheets not filed for 10 years, there are charge sheets filed in 15 days. There are people arrested in heinous offenses, reasons to believe, but there are some people who are not arrested at all. So, police custody, again, there was a valid reason that in the first 15 days, somebody may just get into the hospital and take away the police's power to take police custody in the first 15 days. A genuine problem, right? But the way the section is drafted now, it can be argued that you can also take PC for a longer period than 50 days. Why? Because you wanted to, although you repealed the law, you came up with a new law, but you tried to insert this into the already convoluted section 167 subsection 2 proviso, because it's one of the toughest things to understand in law, by the way, for everyone. You try to retroactively introduce this newfangled idea into an older amendment, you can sometimes just redraft it by scratch. It might be simpler. Deemed sanction, again, an absolute horror show of a section. You have somebody, so certain people you need sanction before you prosecute them. Now this law says, for what used to be 197 CRPC, I for the life of me don't know what the new section is. It says if sanction is not granted by the sanctioning authority in 120 days, it would be deemed grant. Now why should a person who's in the shoes of an accused, just because his superior did not answer a letter or a chitti, why should you presume grant of sanction and prosecute him? And something like this was, if I'm not wrong, also held to be bad or unconstitutional back in the day. But the problem with the amendments is, and this is what you need to do when you are amending, you need to take a survey of where the law stands. The law was not only CRPC, it was judgments on a number of things. You had to capture them and put them on a statutory footing. And wherever you didn't agree, and you probably could take away the basis of the judgment, then take away the basis of a judgment. So none of that survey, I think, took place in a lot of ways. Missed opportunity is victim rights. You've said victim would be informed of the status of the investigation. How? Nobody knows. What point? Nobody knows. In what format? Do you tell them, yes, we are investigating? Is that a good update by the investigating officer? I'm going to file charge sheet in the next few months. Is that a good update? So you went in the right direction, but never went far enough. 340 is a big problem. You know, that's a personal pet peeve of mine. Unfortunately, the biggest problem currently, 74% of all cases are criminal cases. Nowhere in the world you have that statistic. It's a very disturbing piece of statistic. I think I'm too vehement. Even the board agrees with me. 74% of all cases being criminal in nature, which comes to, my colleague tells me, about 3.5 crore cases, criminal cases. Most jurisdiction would have personal injury cases, or civil cases, or commercial cases, and tort cases, and other. We have over-criminalization. Do we commit more crime? Probably not. But I think we convert patently civil and other matters to criminal more, because we've realized in the heart of our hearts, and I'll mince no words, that sometimes a local station house officer can enforce a contract better than a civil court can, which would take decades and decades and decades to enforce a decree that it has passed. And probably that's why we believe in reincarnation too. You'll probably get the fruits in the next birth.
We talk about decolonization of our law, but again, I speak as a student of this subject, is what I have seen that the most application of mind that has happened with respect to these laws is by our colonial masters. There was a consolidated theory of utilitarianism. Crime is a wrong, crime is a harm, crime is bad, punishment is also bad, but punishment is only justified to protect society. So punishment and the adequate amount of punishment is correct because that wrong is justified, right? So the colonial masters, for whatever reason, were very mindful about the amount of punishment they were putting out. We don't have that. We are putting out punishment just on the basis of optics. Rape happened, death penalty. Child rape, death penalty, right? But is that what is necessary? Is that what we need? Any wrong happening, fast track courts, special courts. Do we have the manpower for special courts? Is it the same judge wearing multiple hats? So every single action is ad hoc. What is not understood is that substantive law, procedural law, evidentiary law, they're all stacked one upon the other, right? One tells you what is a crime. One tells you how it's to be investigated. One tells you how it is to be proved, right? It's all a part of the same system. But we do this as though these are separate units which have nothing to do with each other. They're not talking to each other. And structural change requires deep thought.